think you scoot closer. You need to be the same, or at least sit up.
I can't, you gotta.
There you go.
Great, new photo.
Okay, start talking.
Hey, good morning. I'm Chris Parker. This is Chris Nishihara. We're with the Ishihara and Parker Law Firm here in Longview, Texas. How to think about it. And today we have a new topic we thought of what if we are in that trusted role? What if we're the advisor? What if we have been named as, let's just say, our parents' power of attorney, Kristen?
Sure.
What does
yeah.
that mean?
Well, lots of kids or parents hopefully share their plan with kids, and I know kids don't necessarily understand the role, so they say, "Well, I'm mom's executor," or "I'm mom's power of attorney," and don't really know what that means. So we did a video earlier on, what if you're the executor? Again, just as a reminder, executor, you are not someone's executor until they have died and the court has appointed you as executor. So it would be incorrect to wander around saying that your mom's executor or dad's executor. You are named to be the executor of their will once they pass away and the court appoints you as such. But the role that you can play now is if mom, dad, or any loved one appointed you to be their power of attorney agent. We're mostly going to talk about this as it relates to being a financial power of attorney agent, but all the terms probably apply for medical agent as well. Financial is just the one that sometimes gets confused. So let's say mom has listed you under a statutory durable or general durable power of attorney, at least in the state of Texas. We often refer to that as a financial power of attorney to help just be more descriptive. But what does that power of attorney cover usually, Chris? Of course, you would have to read the document itself, but generally, what would that cover for someone to help mom with?
So if someone tells me they've been appointed or I'm in that role, the first thing I want to know is where is the original document? One day I may need it, so I want to know where the original. Maybe I don't have possession. Maybe it's in mom and dad's safe. Maybe it's in safe deposit box. Wherever, I'd like to know where the original is. 2, I would like to read it, right? You got to see what the power of attorney says. It should cover just about each and every financial item you can think of. There's a statutory form. It has a nice laundry list. There's also more descriptive power of attorneys that will go through excruciating detail each transactions. Anything from local checking, savings, investments, CDs, handling bills, handling IRS, handling tax matters, handling trust. I mean, there's a laundry list of powers. And your loved one could have been very restrictive in what they gave you. They could have been very broad in what they gave you. So you got to look at the scope of the power of attorney. There's multiple things to look at, but the first thing is to understand what is the scope. Or one of the things is to look at the scope, right? I've had many kids walk in and say, hey, mom gave me this power of attorney. I have the original. I have this broad and expansive power, so I've been ready to do things. And I'm like, well, Kristen, are they ready to do things quite yet? Even though they have all these powers, do they have them now?
Yeah.
Right?
So number one, if you're power of attorney, you need a copy of the power of attorney because, Chris, let's say mom's told me I'm her power of attorney agent. Can I walk into the bank and say, hey, I'm mom's power of attorney. I'm going to write a check on her account?
Yeah. No, those third parties are going to say, great. Most likely we want to see the original. Maybe
They're going to
we're
read
lucky.
it too.
Yeah.
They're also going to read it.
They're going to look over. And I've had some banks point out some very obvious issues. Like, well, you are an agent. You're just the second agent.
Yeah.
Right?
Sure. Yeah, we misunderstand that a lot.
Right? Yeah, like
Absolutely.
you're here, but you're actually down here. Your brother or sister is ahead of you, or the spouse.
Right.
The most obvious problem I've seen is people think they're the agent when they are not yet serving that role.
Sure. So number one is you need a copy because you'd have to present it to anyone in order to actually serve as the power of attorney. And then 2, you need to know what's in it. There's 2 ways that someone can put a financial or durable power of attorney in place. It can be effective immediately. So as soon as I sign that document and have it notarized, I've said this person, the primary agent appointed at the first level, can act immediately on my behalf just as though they were me. So mine says my spouse can act on my behalf. It does not matter if I'm incapacitated. It does not matter if I'm sitting right next to him. I've authorized him in writing to act on my behalf. Now, he does it as my agent, so he's supposed to do what I have instructed him to do or what I would want him to do in my situation. But I have said effective immediately, he can do it.
That's right.
The other option for financial powers of attorney are what's called springing powers. That would mean it's not effective now. It is only effective in the event of my later incapacity, or disability. So, of course, when I'm signing the power of attorney, I have to have contractual capacity because I have to understand who I'm putting in place. So, I do have to have capacity to sign the document. But then I can say the document doesn't come into play, that agent has no authority to act on my behalf until I'm later determined incapacitated to handle those financial affairs. The document itself would probably say what triggers that event. It would often be a letter from a doctor saying that I'm unable to handle my financial affairs. Typically, now we're not making broad advice here, but typically, Chris, what do we recommend when we do powers of attorney with clients as far as which way to do that?
Yeah, now remember, we are here in East Texas, and so we may have a different geographic specialty or location than you have in a Austin, Dallas, or Houston, Shreveport kind of area. I prefer, and I think you agree with me, we prefer immediate powers of attorney. If I've got a good trusted spouse, if I have good reliable children or reliable friends, I want them to have that power immediately, because if I need help, I want them to be able to do that.
It's often going to be an emergency.
Yeah, there's not like I need you just to go buy a car for me. It's because I just got hit by a car.
Right.
The other ones are the springing power of attorney. I see many people show up with those, and they sound great. Oh yeah, I have this power of attorney that just springs into existence, except the triggering event, that letter from usually a neurologist, the field in which you're afflicted has to write a letter. Well, at least where we're at, there's not a ton of that kind of medical professionals that just have free time to pick up clients on an emergency basis. Not to mention, if I'm the proposed person in this case, I don't want a letter out there from a doctor saying that I lack capacity. That's the last thing I want. If I ever regain capacity, I guarantee you every financial advisor, every bank, every insurance company will say, well, that's nice, Mr. Parker, but we'd like to talk to someone else.
Yeah.
So I don't want that letter. So for me, if I've got good, reliable people who presumably I do, or I'm not doing my power of attorney, I'm going to give them that immediate power to act on my behalf. That's an agency relationship. It's so powerful. It's more powerful than marriage, I argue. But I have seen people go the other way. It's just that's a lot more steps, and the end result is usually a letter saying that.
Sure. At the end of the day, typically the situation is that someone doesn't fully trust the agent that they're appointing, and that really is the problem. If you have a trusted agent, then making it effective immediately doesn't mean they're going to go act on your behalf, and that's the message for the person appointed. You don't have to do anything until that person needs you, but having it effective immediately allows that trusted person to step in when they need to. If we make it springing for that trusted person, we've just made it harder for them to do what we need them to do. And if you have someone that you don't trust that you're appointing in that, then that really is the underlying problem. You need to go to Sunday school, make some friends, make friends with your neighbors, find somebody that you can put in that situation. So that's a good question, Chris. We're talking mostly about a parent appointing a kid. Can you be appointed a power of attorney agent for somebody else, like a neighbor or just someone you know?
Absolutely. Happens all the time. I have folks come in who say, I am single, I am widowed, I have a small family, I have bad relationship with my children. I tell people all the time, listen, you drive less miles you did when you were younger. You do less activities. Your circle has shrank. You have to push against that. I don't care if you're wall walking, going to church. I don't care if you're Walmart walking. I don't care if you're looking at birds, whatever. Join a group or a club. Make some friends. You need these people in your life when you get older. It's just as simple as that. I have so many folks who are still of sharp mind or whatever, but they're stuck in places where they can't necessarily take care of business, and they're going to recover, but they want to recover back to their own things. They still want to have their house. They still want to have their car. They still want to have the money in the bank, which means they need someone just to cover that gap period when they're either incapacitated or tied up or unavailable. It happens. I mean, being sick and having accidents is just a regular part of getting older, and you got to have someone able to bridge those gaps as you get older. You just got to.
So you are able to serve, if you're willing, you are able to serve as an agent for really anybody. There doesn't have to be a family connection. Now, should you do that? Now, you don't, if you're serving as an agent for someone, you're not personally liable for any of their debts. You've not incurred anything from serving in that role. That agent typically, if authorized under the power of attorney, is allowed to pay themselves reasonable compensation, so you can't get paid for serving in that role. A lot of times agents don't pay themselves because often it is a situation where you're wanting to help. But you're really, except for the time spent, you're really not signing on to doing anything except for helping in a legally authorized way for someone that presumably you want to help for. But so if I'm the agent, I've been appointed power of attorney. I need a copy of that power of attorney. I need to understand if it's effective now or if to use it, I need a doctor's letter in the future. I need to understand the order of agents. So Chris mentioned this earlier. For you to be able to serve as power of attorney, you need to be at the first level. If you have a sister and she's the first agent and you only serve if she resigns, dies, or becomes incapacitated, then you're not the power of attorney agent. Only sister can serve there. And that's important because if you are going to be the person that's doing the work, you need to be appointed at the right level in the right way. How this often comes into play is, let's say, mom's at the hospital and now you're the one that's there. You're the one that's going to have to figure out how to pay the utility bill, call her cell phone, sign the hospital discharge paperwork. That person appointed is the only one that can do it. They can't authorize you to do it. There is no way for you to serve if you are not the person in the right slot. So just making sure that those are done correctly is very important.
I have had parents come in before, and you have a mom and dad are getting older. They have a trusted daughter, and I've had it before where mom will say, well, hey, if something happens to dad and he needs more help, I would like help taking care of him. So, Dad, what do you think about making me and daughter as co-agents? I have had adult, reliable children serve as co-agents with the parent. You know, I'm not saying that's right for you. I'm saying things to consider because that spouse, with one in the facility or in a hospital or wherever it may be, the other one's going to be under a lot of pressure. They may not want to do it all, or they may want some help. So, but the only way that adult child can actually do that is if they're a co-agent with the person in the spouse.
So what authority does the power of attorney authorize me? Let's say I'm an effective agent now. What does that mean I can do on mom's behalf? Let's say I think mom should move to assisted living and sell her house, or maybe I think mom should spend less money on, Amazon or the TV shows.
Oh, yeah, I understand about it.
Well, whatever. I think mom should spend less money. Yes, thank you. I think mom's spending too much money, and she's appointed me as her financial power of attorney agent, so I'm going to start making these decisions for her. Is that something I can do as her agent?
I love those situations when the mom comes into me and says that their daughter has attempted to take in control.
Always a daughter.
She said that she's not shopping there. They're selling her house. They're moving her. And mom doesn't obviously want to do those things. So then I encourage mom to reach out to daughter and let her know that that's not what she wants to do. And if daughter persists in those actions, then daughter is fired.
Mom is always the boss.
Yeah.
Mom is always the boss. So you can revoke, or the person putting it in place can always revoke your appointment as agent simply by doing so in writing. Their decision always controls. So if you and mom who appointed you as agent are standing somewhere together and mom is deciding that she wants to buy a car and you say, no, mom, you shouldn't buy a car, mom buys a car. Yeah. You have no authority to stop her from doing anything. And in fact, in serving in your agency role, you as agent are only authorized to do what mom has instructed you to do specifically, or what you know mom would instruct you to do if she had the capacity to give you that decision. So you should never be doing something that you know mom would not authorize you to do. You should only be serving in a role as if by extension mom were doing it herself, and you're serving as a further arm for her if she physically can't do it or no longer can mentally do it.
You have to have the ability to contract, basically to create these documents, and you're supposed to have, I believe, that same competency level to get rid of these documents. I can tell you I've had situations where we've had loved ones with diagnosed for Alzheimer's, dementia, or Parkinson's, and their children are at loggerheads with the adult parent needing help. And I usually tell those kids, look, these are sticky situations. Yeah. My advice is if your principal is saying, no, I won't, or I don't want that, or that you are fired, my general advice is that you should consider yourself fired and move to a guardianship stance. You may be right, but if we're having to look at medical expert testimony, you're in the wrong area.
Yep.
At least that's my vote. So if mom is happy and everything's great, no problem. If mom is ambivalent and being taken care of because of her diagnosis, she's not worried about whatever's going on, not a problem. But if there's conflict, if there's division, if there's strife, then these are not the right documents at that time.
And the flip side of that is that anyone you're presenting that power of attorney agent to act under, they have the opportunity to accept or to not accept that power of attorney agent. So even though you are mom's power of attorney agent, if you present that to a bank, they're going to have a legal review. They're going to determine whether they accept that appointment and allow you to serve as agent. So that's an important step of the process, that you may be appointed, you may be effective immediately, you may be acting under mom's best interest and even with her express authority, but you still have to present that power of attorney to an institution or person or entity, and they still have to review and accept that appointment of your agency so that you can then serve for her. Some things that might come up during this process. Do you have some you want to list?
Well, I mean, I'm just thinking wet ink documents. If you just came in on Tuesday to get it signed, and you're down at the bank at Wednesday making major moves, that's a wet ink
After the
document.
week before you told them mom
Right.
had just recently been diagnosed
Yeah.
with dementia and was having a hard time. Yes.
You assigned yourself up for a legal review process that may not go in your favor.
Right.
Absolutely. That's an easy one for me. So people who dawdle, people who wait on these documents, it's a problem. It can very well be a problem.
Although sometimes dated documents also require an
Oddly
affidavit
enough,
being
yeah.
signed saying
Oddly
that they
enough.
are still effective and nothing new has been put in place. If you did the
Yep.
documents in the 80s and you're giving it to a bank just now,
Yep.
they're going to rightfully ask you probably to sign an affidavit confirming you are still the agent and that there hasn't been a new power of attorney put in place. So brand new documents as well as very outdated documents.
Sometimes it's too hot, sometimes it's too cold. Most of this was because it was never shared with a third party like it
Yep.
should have been
Correct.
when these accounts were set up or when the documents were done. So those are some of the biggest ones. Yeah, the legal review process is always kind of a strange that you might run
Yeah.
into.
So if I'm the agent, so if I'm daughter in this scenario, I'm going to ask mom to bring me to her appointment with her financial advisor, get the power of attorney approved by them. They may have their own form that they want you to complete, and mom should do it while she can. You can do it together and make sure everything is done. I'm going to go with mom to her local bank. I'm going to meet her favorite teller that she sees every Friday when she pulls out $200, and I'm going to make sure they have my power of attorney, or I'm on the account in some way, or I have set that up correctly. I'm going to go with mom and meet all those people as soon as she tells me I'm her financial power of attorney, because I need a relationship and I want to go ahead and do that legal review, get everything clear, make sure I'm set up if I need it. And then if I need it in the future, great. I'm set up. If I don't, even better.
Yeah, it does take some time of the agent's time. So the child needs to
Yep.
spend some time getting this right. It's better to spend some time up front than
Correct.
a whole lot of time later. Let's say I did it all right. I did the insurance, I did the banks, I did the retirement plans, I did everything. And then, of course, mom's social security check has, for whatever reason, has a glitch. It's not being deposited. So I march right down to Social Security Administration. I plop down my properly done powers of attorney that I've shared with everyone. And what happens at the Social Security office?
Well, so back to the last point, that people get to decide whether they accept powers of attorney or not. Social Security, as a rule, does not accept powers of attorney. They only speak to the person, or you can go through the process of becoming that person's authorized representative payee, but they do not care that you are the power of attorney or the guardian. So that is a process in and of itself. So referring back to, I think, point number 3, which is getting that in place if you need it. And understanding whether the agency will accept a power of attorney. There are some that just don't. That's one. The VA is one. So, there are entities that will just not accept the power of attorney, and you'll have to go through a process which may be 100% different than even signing something.
Power of attorneys are great tools, super useful. Use them all the time. And for the vast majority, 90% of the people we work with, that's all that they need, I'd say.
Yep.
However, or what we're trying to avoid is having court involvement in families that don't necessarily need it.
Yep. So if you have been told by a family member or loved one that you have been appointed their power of attorney agent, or they called and said, hey, can I appoint you as power of attorney? 1, get a copy of it. 2, read it and understand it, or ask somebody to help you understand it to know if it's effective now. And then also what line of order you're in. Are you number 1? Are you 2, 3, 4? Where are you in the order? And then 3, depending upon the relationship, if it's mom, have her take you around and make sure that we've entered that power of attorney in other places. If you're number 4 on the list, you probably don't need to do that. But somebody should be doing that to make sure that mom is protected, so that if she needs help, she has put in place the trusted person that can do it. Hopefully you're that trusted person, and this has given you some good advice on things you might need to make sure you know how to do.
Because if this fails, if this doesn't work, if you hit a roadblock and someone tells you no on an essential item, then we're looking at a guardianship.
Correct. And all of this actually would apply to a medical power of attorney as well. So if I'm medical power of attorney agent, that one just across the board does not apply unless mom can't answer her own medical decisions. But if I'm appointed as her medical power of attorney, I do probably want to go to the doctor with her sometime or make sure that that's on file with her doctor. So if I need to get records in the future, that's another good one to make sure you understand where you are in the order and that you've got that entered or filed at the right places.
Unless you're in the medical field, last time I listened to some of my clients talk about the medicines, names, and types they're on, I thought they were reading a word. I mean, it's like 10 medications of names I couldn't pronounce. And so unless you're in the medical field or have some knowledge there, you're going to want to have some building block or you're going to not know any idea what's going on with your loved one.
Yeah, it's pretty convenient now that everything is, online a lot. You can give access online so that if there's questions, all those things, that can be very convenient as far as helping with healthcare. But anyway, so number one, make sure if you are appointed, you have a copy. Number two, understand if it's effective now, where you are in the order. And three, make sure it is given to or filed with the correct people so that if you need to use it, you're in good standing to use it. So anyway, anything else?
That's it.
All right. Thanks for joining us, guys. We'll see you next time.